A very good morning to all my dear students and listeners. Today we are going to discuss about the drafting of review petition under the subject captioned as drafting, pleading and convincing. My dear students, as you all are aware that this topic, that is the review petition, has been provided under unit number 2 of the university syllabus. As far as the word review is concerned, the same has not been defined under the relevant law, that is either CPC or CRPC as well. But my dear students, before starting with today's topic, that is drafting of review petition, I just want to apprise you with the law relating to review as provided under the Code of Civil Procedure for the better understanding of the today's topic, that is drafting of review petition under section 115 of the CPC, 114 and order 47 CPC, whereas section 115 CPC provides the ground relating to filing of revision petition. As far as the law relating to review is concerned, as I have already apprised you that the same has been provided under section 114 and order 47 CPC, wherein we may define review or explains review as an exception to the rule that once a judgment is pronounced and signed, the court pronouncing it becomes functus officio. Further, review means a judicial re-examination or reconsideration to correct apparent error. This was so held in the case of S. Nagaraj and others versus State of Karnataka, 1993, Supplement 4, SCC 595. My dear students, section 114 and order 47 of the Code of Civil Procedure 1908 lays down the procedure for a review of decree or order, an application for a review of a decree or an order is made to the court which has passed such decree or order, or to successor or to his successor in office, subject to the period of limitation. Any person who is aggrieved by a decree or order from which an appeal is allowed by this court but has not been preferred or by a decree or order from which no appeal lies, or by a decision on a reference from a court of small cause, may apply for review of the judgment to the court which passed the decree or made the order, and the court may make such order thereon as it thinks fit. Where an appeal has already been preferred against a judgment and decree by one party, an application for a review of the judgment by another party is not barred unless the grounds of appeal and application are the same, or when the applicant is a respondent in the appeal can present to the appellate court the grounds on which he applies for the review. This was so contemplated under Order 47, Rule 3 of the Code of Civil Procedure. An application for a review of the judgment may be made within 30 days from the date of the decree or order, or any of the following grounds. Number 1, discovery of new and important matters or evidence which after the exercise of the due diligence was not within the knowledge or could not be produced by the applicant at the time when the decree was passed against him. Number 2, on the ground of some mistake, error, or error apparent on the face of the record, or for any other sufficient reasons. So from this, my dear students, we may infer that review on the grounds of discovery of new and important evidence of such nature that it would alter the judgment under review is permissible if the court is satisfied that the party adducing the new evidence could not have possessed the knowledge of it despite due diligence and thus have failed to produce it before. This was so held in the case of Rajan Kotagiri V.S. Rao versus Raja V. Rao, 1899 to 1900. The application for review of judgment is in the form of memorandum of appeal. So my dear students, while drafting a review petition, please keep it in mind these principles for drafting the same. That is, the review petition must be in the form of memorandum of appeal, and is presented to the judge whose judgment is sought to be reviewed, and in case of his death or transfer to his successor in office, as far as possible, the very judge who passed the decree shall hear the application unless he is precluded from hearing it by absence of, or any other cause for a period of 6 months. Next, after the application, after the receipt of the application, a notice of the date fixed for its hearing shall be served upon the respondent or opposite party, and then both the parties shall be heard. The law does not permit a second review. Also, a review is in accordance with law as it exists on the day of the application, unless the statute has retrospective effect. This was so held in the case of Raja Shatrajit versus Muhammad A. Khan, EIR 1971, Supreme Court 1471. So my dear students, this is all about the law relating to the review. Now I just want to provide you the format for filing the review petition. As you all are aware that it must be in the form of memorandum of review petition, and the relevant provisions needs to be quoted over herein. That is under section 114 of order 47 and rule 124. And in case the review petition has been filed in case of a writ petition as well, then please mention article 226 of the Constitution of India. Thereafter, you have to give the designation of the court as well. In the High Court of Judicature of Andhra Pradesh at Hyderabad, review petition number so and so, in WPC number, that is writ petition number so and so year. Thereafter, my dear student, you have to give the name of the parties. Here we are giving the name in the matter of Mr. X so and so petitioner versus state respondent. The address for the service of all the notices and the process on the above named applicant or the revisionist is that of his counsels, Messer so and so. The memorandum of review petition is filed seeking to review the order in the WPC number so and so, dated so and so, passed by Honorable Sri Justice so and so for the following reasons. Now, as I have already mentioned you that it has to be accompanied with the grounds. So this honorable court disposed of the writ petition on so and so, thereby directing the respondents to do the needful. Second, the mistake is neither willful nor justifiable. Number 3, the orders of the High Court dated so and so may be reviewed in the light of the orders passed by Honorable Supreme Court of India in civil appeal number so and so. The other grounds will be urged at the time of hearing. So these are the grounds which you may take while drafting a review petition under section 114, read with article 226 of the Constitution of India. So in the end, you may give or you may pray before the Honorable Court, as it is therefore prayed that this Honorable Court may be pleased to and pass such other orders as it may deem fit and proper in the facts and circumstances of the case, and thereby to review the order dated so and so. Thereafter, you have to give the date and the place, and the application needs to be signed both by the petitioner or by the applicant or by the and also by his counsel of the petitioner. So my dear students, this is all about today's lecture. Hope you have learned a lot out of it. In case you are having any query with regard to today's lecture, then you may write it to me at my email ID, that is rahularoda.gn@jagannath.org. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on general principles as to criminal proceedings or criminal pleadings. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy.